Welcome to Inheritance Solutions for a Diverse Community with Richard Hall. Join us as we delve into strategies and insights that ensure your legacy is secure and your loved ones are cared for.
Hello and welcome to Inheritance Solutions for a Diverse Community with Richard Hall and David Pereira of Bottom Line Lawyers. They combine extensive legal and real estate expertise to help clients with estate planning and to protect their families' futures. I am your host, Kevin Rosenquist, and today we're going to talk about planning for aging parents, the legal tools to support their independence. Richard, David, great seeing you again.
Great seeing you, Kevin. Thank you so much.
Great seeing you too.
So what are the key documents that aging parents need to have in place if they're going to protect their finances and as well as their healthcare wishes?
That's a great question because when you put this together, most people say, okay, I want a trust or I want a will. But when you do the entire estate plan, there's several documents involved. Yes, there's a trust, and that is really the contract of how you're going to handle the estate. But then accompanying that is a pour-over will, which is a very limited will that its sole purpose is saying, hey, if I forgot to put anything in my estate, I leave it to my estate, and that type of will doesn't have to be probated. And it's an essential document. And then you also have a power of attorney, and that power of attorney, the ones that we like to do are what are known as springing, which means they only go into effect when the person becomes incompetent, and they're durable, which means that it survives their incompetency. And the sole purpose of that is to avoid having to do a conservatorship if they become incompetent along the way. The next document would be an advanced healthcare directive, which again, generally kicks in when you can't make the decisions for yourself, and it kind of gives an instruction to who you give that authority to as to how to handle their healthcare decisions. And and that's kind of the whole big picture. So it's a lot more documents than just merely having a trust.
Yeah, I would actually throw into that mix, although it's not a document that our client per se creates, but they better be aware that there's a need for it. Is if they own real estate, we need a deed. We need a grant deed to transfer property into the trust. Because if that doesn't happen, theoretically, it's not in the trust. Now, there is a workaround for that just adds time and money to the process of trust administration, if that's the case. But the simplest thing is to make sure you get that deed in the first place. And it's very simple. It's, John and Sally hereby grant to John and Sally as trustees of the XYZ Trust the following property. Boom, done. And that means it is exactly owned by the trust. And that's what needs to happen in order for the trustee to be able to manipulate that asset as directed by the trust.
Seems to be a running theme on this show. If you don't plan properly, more time, more money. Always the case, right?
Yeah,
Exactly.
I would throw in that actually, and when someone passes away and you have the properly handled, as quickly as you can get a death certificate, as quickly as how you can transfer that to the new successor trustee, and it's without court intervention. It's real fast.
I'm going to toss one other thing in there. It's not directly responsive to what you're talking about, but we're in California. And California has something called Prop 19. And, we've talked about one of the assets or benefits of a trust is a stepped up basis. I think in a past episode, we explained that so that you don't pay a lot of capital gains tax. But the other tax on property is your real estate assessment that you're going to pay to the county assessor. And in California, under Prop 19, if you're leaving your property to a family member like a child, they can move in if they do so within a year, and that property will not be reassessed. There's caveats all about that. There's some red flags about that. But nonetheless, if they want to avoid both capital gains tax and a property tax reassessment, they better be mindful of that. And I think it's the obligation of the legal advisor to make sure that they're aware of that.
Can you elaborate more on the durable power of attorney versus the healthcare directive? What exactly is the difference, and why are both of them needed?
Yeah, that's also a real great question. It's one of those kinds of things that they have two different purposes. They're both forms of powers of attorney, but one is for finances, and that's the typical power of attorney. and the other one is for healthcare only. And in California, that's kind of split into two different categories. The healthcare is limited to only power related to health decisions, and then the durable power of attorney is really focused on the financial aspect of things. And so they're both essential documents. You can't really do things properly without having both.
So one of the things we frequently tell clients is if you don't have anything else but a will and a power of attorney, at least have those two items, because the power of attorney, if something happens and you for some reason are not legally competent, the only option that your friends and family have is to go to court and establish a conservatorship over you, which is really expensive, really time consuming, and frankly, a pain in the neck. But somebody's going to be around to pay the bills and make the various decisions. And that doesn't happen unless you have a power of attorney in place.
Does it automatically become your spouse in that scenario, or not necessarily if you don't have that power of attorney?
Not necessarily at all. It's you get to pick who's going to be your power of attorney. So there's not going to be a default. And as a matter of fact, if you don't have a power of attorney, even who's going to be appointed conservator is going to be another issue for litigation that people could fight over. So having that power of attorney eliminates that fight.
So to put a little bit of a spin on David's answer, which is exactly correct, is that if your spouse is still surviving and they already have access to accounts and decision making and like that, and it relates to community property, then they're going to be able to do most of what they need to do, although not all of it. But if they aren't like listed on your accounts, if they're not on the deed to the property, if they're not the enumerated owner on any of the assets, it's going to be a problem. It doesn't automatically, to answer your question directly, it doesn't automatically devolve to the spouse. It's going to depend upon who's been appointed. And if no one's been appointed, you're going to have to go get that conservatorship to deal with that.
I'd be willing to bet that a lot of people out there listening to this did not know that, because I know I didn't. I think you just assume it's like, oh, it's the spouse. You know what I mean? Like it just kind of like
Right.
it seems like a logical assumption.
Yeah, I mean, if you have to end up going to court over it, generally the spouse is who the court's going to look to as the first level of that. But, especially in a blended family situation, you could have a situation where the children are going to want to fight over that. Say, no, 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 I want to do this. So, uh, you really don't want to go that route. You want to make sure you have it all laid out.
And we, in our firm, we do a lot of work with non-traditional families, whether they're same-sex couples or otherwise. And you really need to spell that out in that particular case, because it's not going to immediately devolve to the spouse or the registered domestic partner or just the life partner. You've got to spell out that power of attorney, what you want them to do and not do. And, I can tell you horror stories. I won't take your time up with it right now. But if you don't do that, your whole estate plan can be undermined.
When you have adult children that might want to talk to their parents about an estate plan, what they're doing, all that stuff, obviously it can be a tough conversation. You guys have been doing this a long time. Let's put your therapist hat on now. How can adult children have these conversations or start these conversations without causing family tension, without appearing overbearing or selfish or any of those things?
Yeah, gee, I wish, I could say some magic thing right now that would make that all just go away. But in all sincerity, it's going to be different depending on the family. But
Yeah.
generally speaking, there should be a good conversation and laying out from your personal perspective as to what you feel your responsibilities are. Like we've discussed in other podcasts, that it's not unusual that sometimes children of the family will feel kind of entitled, it's my inheritance, and it's only their inheritance if there's something left when they die and they've left it to you, and they don't understand that. So I think having that serious conversation, making an understanding what the priorities are, laying that out ahead of time will probably tone things down, but you still could get someone that feels kind of entitled. And
I think they need to come at the conversation from the perspective of what are they, the children, going to have to do when mom and or dad pass, as opposed to what are they, the children, going to get.
Oh yeah, yeah, yeah,
They
yeah.
really need to come with a different attitude. It'll eventually reveal that to some extent. But remember, the beneficiaries have no right to know what's in that estate plan, none whatsoever, until it becomes final. It only becomes final and irrevocable upon the passing. So approaching it from the point of view, what do I have to do? Are you naming me as trustee? Am I going to be your agent? If I'm going to be your agent under the power of attorney for healthcare, what do you want to have happen?
Mm-hmm.
What do you want to have? Do you want to be preserved until the last possible minute? Or you want me to make an assessment about, well, you're never going to be able to enjoy life again, so let's pull the plug. I need to, as your agent, I need to understand those things. And so that's why we need to have that conversation.
Yeah, uncomfortable but important.
Exactly.
Yeah, yeah.
and I have to
Are
tell you,
the
with signing off estate plans routinely, it's a very uncomfortable conversation going over the healthcare directive, the decisions
yeah.
that have to be made, but it's real important.
What are the legal implications when parents begin experiencing cognitive decline, but haven't made prior plans, haven't had these discussions?
Well, that could present a real big problem because the moment you get maybe an early diagnosis of something, uh, that's when you got to move. Because the moment you become declared incompetent, all your options are off the table. You can no longer decide what it's going to be. So we routinely will hear that, okay, I have early onset dementia. All right, we need a note from the doctor. A lot of times we'll ask for that says that they're still competent in order to execute a trust at this particular point. So you can see how important that is because the moment a doctor says, no, I can't sign anything that says that they're competent, all bets are off. You can't create a plan for them. So that's why it's really essential the moment you start to see the decline to make sure you have everything in order.
Yeah, I couldn't agree more with that. And it's not a binary occurrence. It's not today you're fine and tomorrow you're not. It's a linear occurrence. And so you begin to slip a little bit, and then you slip a little more, and then you slip a little bit more. And there are moments in there. We've had people who don't know their name in one particular hour. Another hour, they could, recite the Constitution from memory and tell you the name of every child and their birthdays.
Mhm.
It's pretty remarkable the variety of experience that they have. So really, once you get that first indicator that there may be a loss of legal competence, that's the time to act. The alternative is a conservatorship later, much more expensive, much more problematic, and a court's deciding, and not you.
Does a trust help protect an aging parent's assets from mismanagement, or will it help protect them from any sort of elder abuse that could transpire?
Yes, it very clearly defines how the assets are to be handled. Not to say that there's unscrupulous people that will still try to get around all of that. That's the realities of life. But in general, it's very clear how you want things handled, and you designated that before you became incompetent. But as you get older, you have all these people trying to take advantage of elderly people. It's tragically sad.
The scams that I've seen are where there hasn't been estate planning in place, and it's simple. They can go in and persuade a person to sign this piece of paper, whatever. We had one a few years back where the neighbor started taking care of the one fellow who was not feeling well. They managed to pull $125,000 out of his safe and take that. Then when he was in the hospital and he was on drugs, they went in and had him sign, and they notarized a document that said, everything I've ever owned in my entire life, including my home, is yours. And if
Wow.
that kind of a transfer can't take place if you've got a trust in place, there are more impediments, more hurdles for somebody to jump through in order to do that. So yes, it is a form of insurance against someone trying to exercise undue influence or to literally to defraud you.
My dad decided to do his online, his estate plan online. I'm terrified to know what that's gonna how that's gonna go. What are some of the dangers that you've seen of doing an estate plan online so that I can show this to him and he can get it taken care of properly?
Well, I'm going to jump in ahead of David on this one because I want to tell you, I've had clients come in and they say, well, we were we did one with LegalZoom. And I said, oh, that's wonderful. I love LegalZoom. I get so much business from people who screwed up their own trust. and it's not to fault LegalZoom. They're trying to do something that's important, but folks don't understand the complications. That's why you have attorneys to go through this. This is why litigation goes on for years, is those provisions in a trust are not necessarily what you think they are. And so I think it's a gross disservice to your beneficiaries to try and do it yourself. A DIY is not good. I will give you an exception. And the exception is, because I've actually got a post up about this, when someone doesn't have very many assets at all, and it's a very simple estate, then I think it's a great idea to do a simple holographic will. A holographic will is accepted in California, and there's a template in the process for that, and I can send you that if you're interested. But it is well accepted. What isn't so well accepted is a power of attorney that's handwritten. And so you really need that power of attorney, because what happens with most people is that they begin to lack some competence. They're not computing, and not firing on all cylinders. Right. And so that makes their whatever they choose to do something that can be challenged. Sorry, David, didn't mean to jump on you.
No problem. I think you answered it well.
You said you make a lot of money off of people who do this, or off of LegalZoom. Is that when they realize they need to make adjustments, or is that after they've passed and people come to you and are like, this is what my parents did, help?
Yes.
Yeah, it's after, generally after they pass.
It's really both.
We like to think of that as the bottom line lawyer's employment plan when you do that type of thing. In all sincerity, generally they have complications, and you have to go to court and get it cleared up. And so that's it's good for us in some respects, but we don't want it to be that way. We'd rather it be done right in the first place. That's what our job is.
Let me give you a real world example, Kevin.
Love to.
Appreciate this. We had someone come in. They had a trust, quote unquote, that was 4 pages long, which the length is not determinative of the validity of the trust. But there was too much left out on that trust, and within the trust, it was verbally inconsistent from one provision to another. So 3 years later, I think just a couple months ago, we finally completed litigation on that and got a settlement out of it. Cost a bunch of money to the beneficiaries, took a lot of time, and was not necessary if somebody had simply done the trust correctly in the first place.
Yeah. That's I've heard that before, and I feel like that's sort of common knowledge. A lot of people know, like, these are important things. You need a professional. So hopefully anyone listening to this who might have been considering doing it themselves will rethink that. We can hope, right?
Exactly.
I would say a final statement, if you don't mind, that keep in mind, everything is hard to do when you don't know how to do it, and doing an estate plan is right in that category. If you don't know what you're doing, it's really hard. We do it all the time. It's fairly easy for us because we really know what we're doing, and we have a lot of good processes in place.
Yeah, definitely. I'm very much a go with the pros kind of guy. I just think that it's just in all kinds of different areas. I'll try to do some home projects, but there's certain things where I'm like, I'm going to call someone who knows how to fix an air conditioner.
Yeah.
Right.
All right. Well, thanks for listening to Inheritance Solutions for a Diverse Community with Richard Hall and David Pereira. For more information, visit bottomlinelawyers.com. And don't forget to subscribe to our channel and leave us a review if you can. We very much appreciate it. Gentlemen, I very much appreciate you both being here. Richard, David, great to see you again.
Thanks, Kevin. We'll see you again soon. All right.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.